Good evening. We welcome you at the entrance, and today we are going to discuss about the topic triple talaq. Triple talaq is the most debated issues in Muslim law. What actually is talaq? Talaq means the liberty from the relationship of marriage eventually or immediately. Triple talaq has no mention in Sharia Islamic law or the Quran, even though the practice has existed for decades. Most Islamic countries have already banned triple talaq. For example, UAE, Pakistan, Bangladesh, etc. There have been cases in which Muslim men in India have divorced their wives by issuing the so-called triple talaq by letter, telephone, WhatsApp, and custom. We will see the dissolution of marriage under Muslim law. The marriage in Muslim law is dissolved by four processes. First, by husband. Second, through wife. Third, through mutual consent. And fourth, by judicial process. The first, husband. Through husband, the modes of talaq is two. First, talaq-e-sunnat, and second, talaq-e-biddat. Talaq-e-sunnat is the traditional form, and talaq-e-biddat is the new form that has been conformed with the changing times. In talaq-e-hasan, talaq is spoken once and the wife has to observe an iddat period of 90 days. In talaq-e-hasan, the talaq is pronounced 3 successive times in 3 months. Further, the talaq-e-biddat. The talaq-e-biddat is also called the triple talaq. In triple talaq, talaq is spoken thrice in one go. That is, talaq, talaq, talaq. In triple talaq, there is no time for conciliation, and it can be spoken at any form in any way. We will see the landmark case of triple talaq, that was Sharabano versus Union of India. Sharabano and Rizwan Ahmed were married for 15 years. In 2016, husband Rizwan Ahmed pronounced talaq by way of triple talaq. Therefore, aggrieved by this, Sharabano filed a writ petition in Supreme Court against the divorce and other personal practices of Muslim law. She challenged certain practices, saying that they violate Article 14, that is equality before law, Article 15, prohibition of discrimination on the grounds of gender, Article 21, right to life, and Article 25, freedom of religion. The 3 practices that she challenged were instant triple talaq, nikah halala, and polygamy. As we discussed, we know what is instant triple talaq. We will see what is nikah halala. Nikah halala is the provision for remarrying. That is, if a man wishes to remarry his wife, then the wife has to observe an iddat period for 90 days first. She has to marry another man and consummate the relationship after that. After consummation of relationship, the wife needs to divorce the lady again, and the lady has to observe the iddat period of 90 days again. Then only the husband can marry the wife again. The third practice was polygamy. In Islamic law, we know that Muslim men can have more than one wife. Further, Supreme Court constituted a 5 judges bench in February 2017, and there were 2 main issues that were formed. The first issue was whether instant triple talaq is essential religious practice of Islam. Second, whether triple talaq is violative of fundamental rights. The 5 judges bench were: first, Chief Justice of India Jagdish Keher; second, Justice Kurian Joseph; third, Justice Rohinton Nariman; Fourth, Justice Abdul Nazir. Fifth, Justice UU Lalit. We will look who were the petitioners and respondents. Petitioner, of course, was Sharabano, and respondents were Rizwan Ahmed, Union of India, Ministry of Women and Child Development, Ministry of Minority Affairs, Ministry of Law and Justice, National Commission for Women, All India Muslim Personal Law Board. The judges were of different opinions. That is, Chief Justice of India Kehar and Justice Abdul Nazir, they said that triple talaq is a Muslim personal practice and therefore Supreme Court should not interfere in such matters as they are protected under Article 25 of Indian Constitution, that is, right to freedom of religion. The validity of triple talaq is not to be decided by the Supreme Court, but it is to be decided by the Parliament. Therefore, they imposed a stay on the practice of triple talaq for 6 months. Second, Justice Rohinton Nariman and Justice UU Lalit said that all laws should be consistent of fundamental rights. Article 13 does not challenge triple talaq practice. Anything or any practice that is arbitrary in nature is always held unconstitutional by the Supreme Court. So here the practice of triple talaq is violative of women's right. Therefore, it was held to be unconstitutional under Article 14 of Indian Constitution. Lastly, Justice Kurian Joseph said that the practice of triple talaq was un-Islamic. The practice of triple talaq clearly lacks arbitration and reconciliation. Therefore, the practice of triple talaq is not an essential religious practice. Therefore, by majority, Supreme Court held the practice of triple talaq as illegal. We will see the legal developments that happened in the journey of Muslim protection of rights on marriage bill. In August 2017, Supreme Court declared triple talaq as illegal. Further, there were many cases that were reported of triple talaq. December 2017, bill was presented before Parliament. Muslim Protection of Rights Marriage Bill 2017. The bill passed in Lok Sabha, but the bill lapsed in Rajya Sabha. So, on September 2018, Cabinet passed an ordinance and made triple talaq as a punishable offence, and saying the punishment was 3 years jail. In July 2019, the bill was again passed in Lok Sabha and Rajya Sabha, and it clearly passed in both the houses, and it received the assent of the President too. And thus, it became the Muslim Women Protection of Rights on Marriage Act 2019. We will see the main elements of the Act. The Act declares triple talaq as a criminal offence, that is, in any form, whether written or electronic form, to be void and illegal. According to Clause 3 in Chapter 2 of the bill, the pronouncement would be held to be void and illegal. The Act makes triple talaq a cognizable offence with imprisonment up to 3 years plus fine. Who can file the complaint? Only the wife, the married woman against whom talaq has been declared, or any person related to her by blood or marriage can file the case on her behalf. Bail. The bail may be granted by the magistrate, but only after hearing the women, and then if the magistrate thinks that there are reasonable grounds for granting bail, then bail can be granted. The offence can also be compounded by the magistrate on the request of the woman. About allowance in custody, the woman is entitled to seek allowance for herself and her dependent children. The woman is also entitled to seek custody of her minor children. On seeing all these instances, we can say that the triple talaq practice is arbitrary in nature, therefore it was held to be void, and the commission of the act would lead to severe punishment and heavy fine. Thank you for watching this video. If you have any queries, do mention in the comments box. And please like, share, and subscribe this channel and keep watching the entrant for more interesting videos. Thank you.